the rudder! Raise the sails! Raise the sails!
Captain, an unidentified ship is approaching. Over.
Roger. Wait, is that an enterprise sales solution?
Reach sales professionals, not professional sailors. With LinkedIn ads, you can target the right people by industry, job title, and more. Start converting your B2B audience today. Spend $250 on your first campaign and get a free $250 credit for the next one. Get started today at linkedin.com/campaign. Terms and conditions apply.
The Hilton sale is on. Now through September 29th, you can save up to 20% on stays this fall and beyond. Long weekends, last-minute getaways, holiday gatherings. There's a Hilton stay for all of them. More moments, more experiences, more destinations. Now 20% off for a limited time because it matters where you stay. Don't wait. Book by September 29th and save up to 20% at Hilton.com. Terms apply. Hilton for the stay.
Hey, this is William Tidcup and Ryan Leary, and you are listening and watching the You Should Know podcast. We have Greg Brown on today, and we're going to be talking about non-competes. Evidently, there's been something that's gone on recently, and I can't wait to get everything explained to us by Greg. So, Greg, would you do us a favor and introduce yourself and your firm?
Sure. So, my name's Greg Brown, and I am an attorney in Tampa, Florida, with a firm called Ward & Henderson. And for almost my entire inglorious 30-year legal career, I've handled what I would call sort of roughly business divorce cases, a lot of which have to do with restrictive covenants or non-competes. So I've done a bunch of that work.
So that's a specialization within specialization right there, because knowing it's corporate law, and people can kind of handle a lot of things in there, but corporate divorce, that's actually a good way to think about it, because it is technically it is, whether one way or another, whether or not it's for cause or whether you choose or they choose, it's a divorce.
That's right.
It doesn't really matter.
Yeah.
So my background, I'm gonna date myself, but .com era, a corporate attorney whom I absolutely loved told me, he goes, think of non-competes like this: specific company, specific role, specific time period. And they can't be, you can't not let the other person work. Okay. So it can't be so restrictive that the gal or the guy can't get a job. Like Oracle, chief revenue officer, 3 months. Now that might, and he even said it this, like 99, that might work. This is Texas, so of course our laws.
You have your own law.
Yeah.
You're your own country.
Yeah, pretty much. We have our own energy grid, so at one point we'll just split off. But the thing is like he drilled it into my mind that, okay, the more specific, because people are writing these, you can't compete with our business for 3 years. Crazy stuff. He's like, that's never going to hold up. So just get it out of your head. So again, that was 20-something years ago. That's 25 years ago. So it's dated. So what advice did you give people regarding non-competes pre this ruling by the FTC that we're going to talk about?
Well, that's a great question, and it's interesting because you have this Texas perspective, right? And in Texas, I'm somewhat familiar with Texas law. Right. Litigated a couple cases there, and for you all, that's true. I think the law is such that it's kind of restricted in what you can throw in one of these agreements, right? And in particular, if I'm remembering correctly, you have to provide like some additional consideration at the time the thing is signed, right? So you'd have people that, have been working for 3 years and you decide, now we're going to have everybody sign non-compete. So, it's like, all right, well, you got to, throw them a little bone along the way, whether it's have a bonus payment or something. Otherwise, the agreement's unenforced.
That's
to
exactly
compensate for that.
So, in a lot of states, including Florida, we have what's called the blue pencil doctrine, which allows a court to take a restriction, whether it's a time period, whether it's a geographical restriction, and say, well, that's too broad. You say, a person can't work for a competitor in the entire United States for the next, 5 years. Well, we're going to make it 2 years, and we're going to make it only in the state of Florida. So the court has the ability, rather than throw the baby out with the bathwater and say we're not going to enforce the agreement, to narrow the restriction. So frankly, it states that as a blue pencil doctrine, these agreements are drafted really broad. It's like, as much time as you can possibly get, as much scope as you can possibly get, and then, knowing that the court can kind of reduce that.
Wow. That's what I find fascinating about that is then you let the courts decide on which ones they restrict, or if they go back and kind of rewrite each one of them, there's still going to be restrictions. They don't throw out the non-compete.
That's right. That's right.
Wow.
But these, it's so these things, it's so interesting. Like, and even we'll talk, obviously we're don't want to, kind of bury the lead here, but we'll talk about this new FTC rule. But these, there's always this assumption that, somebody has signed a non-compete agreement and, they've agreed that they're not going to work somewhere, for a competitor for 2 years. And it's really kind of gravely restricting their right to move around and so forth. And the truth is, these agreements are now such a creature of statute, right? So, the extent to which you can even enforce a non-compete really depends on the state in which the person works.
I used to think of non-competes. Now, this is actually a little bit forward, as similar to patent law, in the sense of you can have a patent, which is great, you should, but your ability to enforce that patent that's the game. You've got to be able to enforce it. So I kind of ran the parallel, and I don't know if it's right or incorrect, but I ran the parallel with competes. You might have a non-compete or whatever.
But can you enforce it?
But can you enforce it?
That's exactly right. It was so funny. So you were asking about kind of like what would I tell people? If it came to drafting way back when, I'd say, here, if we're in Florida, draft it as broadly as you possibly can. We want to have all the bells and whistles and so forth. But then I would do talks about enforcing non-competes. And I'd say, we're sitting here in Florida, and I would say, are non-competes enforceable in the state of Florida? Or how many of you think that? And most people would raise their hands. And I'd say the truth is, or the correct answer is almost never, right? It used to be, there were very narrow circumstances in which you can enforce an actual non-compete. That's broadened quite a bit recently, but that's that's just kind of the deal. So I have a non-compete, and I'd look at it and say, what do you do for a living? I work in operations at a security firm or whatever, and I'd say the chances of you of having a non-compete enforced against you are slim.
Why do employers waste the effort then to put them together? Is that just a scare tactic?
Well, it's funny. That's a great question.
It is.
Because
I think it's a scare tactic. Like, you're going to work for me, you're never going to leave.
That's exactly right. And I think that is really kind of the hidden justification for a lot of this FTC ban on them is this kind of like deterrent aspect, right? It's like, okay, we've had these 200 people sign them, and then, I deal with these individuals that, a company that I represent wants to hire away, and they're like, I can't leave. I've got a non-compete. So
and you read the language in their employment contract and go,
that's right. But there's that indenture aspect to it, right? Like, okay, so we're going to kind of keep these people in the fold. But the most prevalent use of these things is with salespeople, particular industries. Yeah. So you get, you have a commercial insurance broker who's got a $10 million book of business, and they leave, and the expectation is that whole that client base is going to travel with them. And the company says, no, that's our asset. You can't take them. And that's the client facing roles in a company, sales folks. And so in particular, that's where.
Hey there, I'm Tim Boris, host of the Working Well podcast, where business strategy meets human sustainability. If you're an executive, a leader, or change maker ready to ditch burnout, build thriving teams, and drive real results, this is your next must listen. Tune in on the Work Defined Network or at timboris.com/podcast.
Non-competes sometimes and non-solicitations more prevalently are enforced against an employee.
It seems like that would be more important as a non-solicitation than a non-compete. Like if you got a $10 million book of business, if you've got a kind of an ironclad non-solicitation, you can go work for somebody else. Great.
You are right on the money with that, because and for a period of time, back when it was hard to enforce non-competes, we would bring an injunction action. If I'm on the side of a party trying to enforce one of these things, or a company, what would end up happening is, especially the way the law is framed, you can only enforce a restricted covenant that is reasonably necessary under our statute to protect a legitimate business interest, right?
Yep.
So kind of irrespective of what side I was on, we'd be arguing that really it's not necessary to keep this employee from working for a competitor, only from calling on their prior customers.
Right.
So we used to carve these things up. We would have, you have lists that would get filed under seal in a piece of litigation with, here are the 20 customers that you can't call on for the next year or 2 years, whatever the time period was.
Now that seems enforceable.
And frankly, that's, when it comes to this FTC rule, I consider myself probably to be kind of middle of the road politically. This is such a political animal.
Oh yeah.
So it is, even in terms of the commission that just voted on it, you got 3 Democratic appointees, 2 Republican, and they voted party line.
Yeah, and this is in their minds, this is pro-labor, right?
That's exactly right. Exactly right.
So let's get into the stat. Let's get into the decision yesterday. What happened?
So this is I'm going to be speaking in somewhat of a derogatory way regarding this proposed final rule. I mean, it's such a Frankenstein to me, and it is. In my view, it kind of invents a problem in order to address it. So the whole premise is, and there's even, if you look at some of the early papers that were published by the FTC in connection with the proposed rule back in January of 20, the justification was like, look, we got these very low-level employees, and they use the example of a security firm, where the actual security guards had to sign non-competes, and they were trying to enforce the non-competes against the security guards. Well, in my experience, 30 years of doing this, that never happened.
No, this is executive level.
That's exactly right. That's exactly right. So for example, I there's a lawyer, particularly aggressive guy, and I have clients that. One of whom was a major league baseball manager who got together and they created this kind of high-end pizza shop or restaurant.
Right.
Hired away these 2 pizza cooks or chefs from this smaller pizza place. And I ended up getting this nasty lawyer letter, from this guy's like, we're going to sue you pizza guys because these pizza guys have signed non-compete.
Oh my goodness.
Do you ever, because I've been sued. I don't know if Ryan's been sued.
Yes.
I think it's one that was an entrepreneur. There's 2 things that makes you an entrepreneur. At one point, you have to be sued.
Right.
And the other part is you have to put payroll on a visa.
Yeah.
Do you, and I've gotten those really, really aggressive letters. In fact, I got a cease and desist from Salesforce.
Yeah.
At one point by Mark Benioff. But do y'all ever get intimidated by the language, or is it just kind of
No, you mean
it's
those letters?
yeah,
Yeah.
like
The letters
we
that
like
he,
those
you
letters.
mean the letters that he writes? No, he
Yeah.
doesn't.
Right, yeah. Come on,
You're
come
not
on, man.
for
Yeah.
defending a non-compete against pizza guys.
All because he
You
put
know.
the cheese on clockwise.
Right. Exactly. Exactly.
Oh my
What's
God.
the adjective? What's the so no. But
So
you're
the example that they put forth is just it's kind of a BS example. Now, if they would have started with, hey, a VP of sales of an insurance company, like we said,
Yeah.
he's got $50 million book of business.
Right.
Okay, now that's a legit that happens day to day. Fair enough.
Right.
But they didn't. They decided. Is that because of labor? Is that because of unions?
Well, I mean, I just think it's just this is such a political creation that. So let's think about this, okay? So the what is the FTC? It's this commission that's designed to, in connection with the Sherman and the Clayton Acts, to break up monopolies and prevent all kinds of anti-competitive behaviors. So the FTC relies in large part on Section 5 of the FTC Act that is designed to prevent unfair methods of competition affecting commerce, right? So there it is. So I
But
think
isn't that company level, not individual level?
Well, that's the thing, is like you have to first, like, this is what I think will be a kind of a principal basis of the challenges. Does the FTC have any jurisdiction or mandate to actually, enter the fray here? Because so you'd say, all right, well, assuming that these are agreements that are really only enforced against kind of high level salespeople or folks with some, executive function, is it legitimate to protect your customer base and that was in part created using your resources over the course of time, and is it unfair competition to say, we're not going to let somebody just take their, ball and go, play for somebody else, at least not right away. So that to me is kind of gets back to this idea of we're inventing a problem so that we can address it. And now there's all these, in my view, unenforceable or will be ridiculously hard to enforce carve-outs in this proposed rule for I'm trying to remember how they phrased it.
In a proposed rule, senior executive.
Yeah.
In a proposed rule, if I remember correctly, it goes through a comment period, right?
That's correct.
So they put it out, and before it becomes kind of a thing, then they vote on it. But they get everybody to comment on it, and they take advice. They have not hearings, but places where people can kind of come and then speak whatever they need to speak. It's a comment period. Great. They take all that into account, and then they draft a final ruling.
That's correct.
Okay. So when would this rule? It's going to be. I'm assuming it's going to be challenged, but let's just say, when is it supposed to go into effect?
So they actually voted to promulgate the rule yesterday. So now it will become effective, I believe, days from when it is put in the Federal Register. Yesterday. So
wow,
that's 4 months from now.
No non-competes, and the rule has these mechanisms, including like a proposed letter that employers are supposed to send to employees to basically retract their existing non-competes.
Oh wow!
Yeah. So it's a sweeping.
Do you think this stands the test of time? Does this remain?
I think it's gonna. This will. And this also will depend in large part on our next administration.
100%.
But it's certainly going to be something that you're going to be hearing about in our, in our presidential election process. Days. But it's just hard for me to imagine that this thing is going to stand up.
Well, I think one of the things that will be attacked and Was it who's on the side? Who's on the other side that wants to kind of like, okay, first of all, the FTC doesn't have, they don't have the authority to even create this. So why are we? The point is moot. Who's that group of people?
I have to say, broadly speaking, they're at this point they're calling them the commenters because the FTC received over 26,000 separate comments. Okay, so this rule was the proposed rule issued in January of 2023. Typically,
Right.
you have a 90-day comment period, but the
Right.
FTC got so much. They received so many comments that they extended the comment period for, several more months. And, here we are in April of 2024 with the rule finally being issued. So actually, I'm sorry, I didn't even really answer your question. I will say that I think, and this may be somewhat industry specific, but it's the business community that's saying this is,
Right.
Right.
you can't get behind this.
And the vote was 3-2.
That's
Did it come down party lines?
Yep.
Yeah.
Party lines, yeah. Yeah. So now, if the vote didn't come down party lines, is this different? Do you see this differently?
Bet some remaining faith in the,
Has it been completely squeezed out of you yet? All right, good.
We're getting close.
He's coming to Texas if it does. He's
No.
going to start a new nation. It's a right to fire, a right to shoot, a right to kill, a right to whatever the hell you want to do, state.
I think you all should secede. It's a great country.
Yeah, Greg, way off topic, but a couple years back I was at William's lake house, his family lake house, and I got up in the morning trying to be healthy. He's sleeping away. I go out. I'm running. Now, I should probably, why don't you set the stage of like where this place is. It's on the water, 17 miles back off the road.
Yeah.
There's a couple of properties. Running down the road, just doing my thing, just running. Gun signs everywhere. Guy comes out, stops me. He said, "What are you doing back here?" I don't know. Like I had to turn around and go back. He did not want me there. And I was like, "William, I need your help."
You were wearing an Eagles jersey. But other than that,
I mean, like they walk around with guns on their back. Like he's just walking around.
Oh, yeah.
Like, where am I? Like I thought he was.
Yeah.
No, he was just
Wild
walking.
West.
it is it's getting wilder. Other than the folks coming in from California, I have to say Austin, it's always been kind of purplish.
Yeah.
Because it's the state capital, so it's conservative, but they also have the University of Texas there.
Yeah.
So it's always been kind of a weird place. With a bunch of Californians coming in, it's actually, I think Austin proper is going to be more blue. But you know what? You drive 30 miles in any direction outside of Austin, it's as red as you can make red.
It's the same here. Yeah. Same here.
Love Austin. I've been there. Yeah. I've been there twice in the last year. I have 4 kids.
Oh yeah,
all different ages, and we took them. We were actually going to go to Denver, and my wife said, "Hey, let's stop off in Austin for a couple of days. I'll make the flights. You make the hotel reservations." I'm like, Sonia, these hotels are $1,000 every one of them. I don't know what's going on. So as it turned out, we got dumped right into South by Southwest.
That's what happened.
Yeah.
Yes.
And so we went and saw the bats. We had a tremendous time.
Oh yeah.
And then I played golf in the foothills.
Oh yeah. UT Golf Clubs actually.
Horseshoe Bay.
Oh yeah. That's nice.
It was beautiful.
Are your kids college age? Are they going to look at the colleges?
Well, I have one that's, but my oldest is now out of school. I got 2 at the University of Florida, and my youngest,
Gators.
about to graduate from high school.
Tuesday on NBC, Jimmy Fallon and Bozoma St. John host the highly anticipated new competition show.
I hired 10 creatives from all walks of life. They will be battling it out to see who can impress the world's biggest brands.
This is a huge opportunity.
This is the battle for the next big idea.
This is not play. We're spending millions of dollars.
I'm so excited to embark on this adventure with all of you.
May the best idea win!
On Brand with Jimmy Fallon. Series premiere Tuesday on NBC.
Wish you could become a morning person? You know the type, up before the sun, early morning runs, first one to the office with donuts and a smile. How do they do it? Easy. With the new Galaxy Watch 8, sleep tracking and personalized insights from Samsung Health help you improve so you can wake up to a whole new you. One who, dare I say it, skips the snooze? It's possible. Train your sleep with Galaxy Watch 8. Learn more at Samsung.com. Requires compatible Samsung Galaxy phone, Samsung Health app, and Samsung account.
Go to the army or prison or something. I don't know.
Yeah.
I don't know.
Yeah.
Prison.
No, he's gotten into a few different schools, so we'll see.
Oh, that's funny. Yeah, my oldest is making his decision this weekend.
Oh,
It's either Texas A&M, the core,
Yeah.
or VMI.
Oh,
So,
good.
yeah, he wants to be a weapons engineer.
Oh, wow.
So,
Yeah.
so non-competes, as you see this playing out, it's obviously going to be challenged. It's probably already started. The process has probably already started
Right.
for it to be challenged. How do you see that playing out? Because they've
Well-
got 4 months to enforce it, or 4 months for it to start.
Yeah. Well, so the way that I would imagine, I mean, you're going to see lawsuits directed at this proposed rule,
Right.
that will challenge the jurisdiction of the FTC to even issue it.
Right.
There will be constitutional challenges to it.
Yeah.
You'll see that, and then what you're also going to see is for folks, boots on the ground like me. I'm sitting on a couple of cease and desist letters from folks who I expect are going to file lawsuits in short order, and then there's going to be questions about the effect that this rule will have on the rights that they're seeking to enforce. Because again, this appears to be designed to prevent the enforcement of non-competes, but we still have non-solicitations, anti-piracy, or non-solicitations of employees. So there's a host of other kind of related rights that I think will continue to litigate, and we'll have some question about the extent to which this rule impacts those cases.
Constitutionally, is it where exactly in the Constitution, outside of the life, liberty, and pursuit of happiness, where else does it fit?
Now you're sort of taking me a little bit outside my wheelhouse here.
Yeah, fair enough.
It's like 14th Amendment type stuff,
Right.
That
Okay.
really, when I say jurisdictional challenges, that really kind of relates back to whether or not the FTC has the jurisdiction to issue a rule like this about this subject matter.
If it weren't the FTC, who would it be? Like I was thinking the EEOC, not the EEOC, the Labor Board. What is that called?
EOL?
No,
the NLRB.
NLRB, which again is also fairly politicized as well. Like, who has the authority?
I will tell you, if it's not the FTC, I think it's NOAA. I think if there's the question is whether or not this is appropriate to federal, because look, right now, and this is even mentioned in the rule, we have a patchwork of different state laws that relate to this, kind of consistent with our new sort of abortion laws around the country.
Right. Let the states decide.
There's some states in which these are, aimed already, right?
Right.
And so that's what we have right now. So I think that's going to be the issue. Is this the proper subject of, federal preemption? Kind of federal law imposed on states.
Do you see it making to the Supreme Court?
Yeah, I think perhaps. I mean, it kind of depends on what happens. If this doesn't get sort of shut down early in the process.
Right.
This way up.
Yeah. And I would imagine, with the makeup of the existing Supreme Court right now.
Right.
Again, I think this one will have a tough road to hoe.
So, Greg, that are already in this process. So they've got litigation happening, or they've got cease and desist letters. You started to talk about it, but where does that leave them? They've left a job. They're in that process.
Good point.
really good question. And there's, so
my mind goes
So
to, do they just delay until there's
Yeah.
a rule?
Well, this is so the law, but the way they're part of the reason I would say this is kind of a Frankenstein is that we have these existing contracts, right? And there's this notion that the government courts and so forth shouldn't interfere in private contracts. Lower level operational workers and so forth. They're saying right now those existing agreements are unenforceable, and here's the letter that you need to send to them saying, hey, now you're free to go wherever you'd like.
Right.
And so I'm not sure I'm prepared to say chapter and verse, but there's also this effort at kind of dealing with existing claims.
Right.
And more or less, I think the statute kind of says, or the rule rather, sort of says, we're going to let you kind of play those things out. So there's what they're generally doing is saying, going forward, you can't enforce non-competes. And then with the exception of senior executives, we're also going to render unenforceable ones that are in place for, mid-tier and lower level employees.
Why'd they leave the senior executives in?
See, there again,
Frankenstein.
This is where I think there's this kind of disconnect from reality, because the senior executives, one of the instances where I think it's perfectly fair to enforce a non-compete is when a senior executive sells a business, right? You sell the assets of your business. That the company that buys it, or the person that buys it, should reasonably expect that you're not going to then form another company to try to poach all your old clients, right?
Right. That's reasonable.
So I think that this is some effort at keeping those folks or continuing to kind of allow the enforcement of the agreements by identifying senior executives. What I will tell you is the way they define senior executive in the final rule doesn't grab up, I don't think, those sort of high level salespeople that these things are typically directed at. They say a senior executive is someone who is in a policy making position, and I sort of think, okay, you got a bunch of bureaucrats trying to define.
These are just guys and gals selling stuff. They're not making policy.
Yeah, it was a policy-making position and received from employment total annual compensation in the preceding year. Seems kind of arbitrary number.
I feel like that's like minimum wage today.
Yes.
Yeah. Especially in California and New York. That's not even a living wage.
That's right.
I'm in Pennsylvania. I went to get gas yesterday. It was over $4. I did not get gas. I said, I'm not doing it. I'm waiting until I'm going to have to go grocery shopping to get my 10 cents off a gallon because I'm not paying
that's fair.
Yeah.
That's
so
fair.
It's so that there's an example now we can still enforce these against senior executives, but now we're have to prove up whether they made over in the preceding year, and we're in a policy making position. It's just it's a mess. So it's going to be the Wild West when it comes to who can be bound by one of these things and to what extent. So
this is why I was never going to be a lawyer, because one, is too complicated. Two, I just want to shake hands and say, "Hey man, it didn't work out. I'm out of here. Goodbye." Yeah.
Who's celebrating today? Who's if you're guessing, who's celebrating the ruling?
Hey everybody, I'm Lori Rudiman. What are you doing? Working? Nah. You're listening to a podcast about work, and that barely counts. So while you're at it, check out my show, Punk Rock HR, now on the Work Defined Network. We chat with smart people about work, power, politics, and money. Are we succeeding? Are we fixing work? Probably not. Work still sucks, but tune in for some fun, a little nonsense, and a fresh take on how to fix work once and for all.
I guess that's a great question. I guess labor is celebrating this ruling. Now, again, in my view, that would be incumbent upon, there being these swaths of people who are like, I signed a non-compete. It's kept me employed as, a janitor or a pizza chef or a security guard. And, now I can't go to work for and to me, the problem doesn't really exist. So I'm not sure there's any, huge celebration other than, so you can fully expect that, the Biden administration is going to allow this and say it's great. Now, no longer can you keep, a housekeeper from moving from, the Marriott to the Hilton. Hallelujah.
Right.
And if you asked someone boots on the ground, that's never really happens anyway. So.
It's not a thing. Yeah. Well, so in our space, in recruiting, in talent acquisition, I could see recruiters being happy with this, right? So Greg, I'm assuming recruiters would be included in that. A lot of recruiters get a non-compete. They can't leave when they leave a company. They can't in turn recruit the employees of that company.
Right.
That's
solicitation. So we call it recruiting, but that's actually solicitation.
Yeah, you're right.
Yeah. And actually, I caught a segment. I would call that like anti-piracy. Like you can't reach back and grab your old employees. And unless I'm missing something here, this rule is really not designed to prevent that from.
It doesn't prevent
agreements like that from remaining in place, right?
Got it.
So, so I will tell you who will be celebrating this in part are lawyers who draft these agreements, who are going to say, okay, now how do we have to carve these things up? What do they have to look like?
Right.
Now, there'll be compliance lawyers will be involved issuing these letters for the retraction of appropriate employees. So I need to make sure that people know that I'm capable of doing that.
So your billings just went up, basically.
I heard cha-ching somewhere in there. But, when you said labor, I wanted to make sure that the audience understands. Is that labor in general or labor unions?
That's a good question. I mean, I guess I meant to use the term agree generally.
Yeah, that's what I thought.
But I would imagine, that labor unions would be sort of behind this to the extent, the senses that it's keeping their folks from moving around for competitive wages and that sort of thing. I think they'll have, labor and support, sure you already did, show the confidence and that kind of thing. So,
but where do we go from here? What's the, outside of the Wild West, outside of lawyers, obviously on all sides.
Yeah,
getting compliant.
I think we're gonna have, there's just gonna be a lot of litigation, surrounding, as I said, kind of directly at this law, and there's gonna be a lot of consternation from a compliance standpoint. How can you do this going forward? Because again, if this rule said, we are banning non-competes, non-solicitations, confidentiality, and anti-piracy purposes, done, that would be sort of a different story. We're going to be left with, what do your restricted covenant agreements look like with your employees? And which ones are appropriate for what type of employees, right? So we're going to have this kind of compliance, in my view, chaos.
Right.
And then separately, we're going to have litigation chaos when we try to determine the effect that this rule has on.
And now you've got judges that are going to have to weigh in and have to read all of this Frankenstein stuff and then say, okay, what I believe it's to say is this, and then rule. And then those rulings are either going to be upheld or appealed or whatever.
Yeah, and one thing that I didn't even think of is, so there's a part of this rule that basically says, to the extent you have state law that is consistent with this new final rule, then that law remains enforceable. To the extent it is inconsistent, that law is preempted by
the federal.
Right. So we're also going to have chaos when it comes to where does a particular cause of action belong? Does it belong in state court? Does it belong in federal court? There's just this, in my view, is going to be a very chaotic process.
If Republicans come in power, how fast would they undo this? I mean, how fast could they undo it? I guess there's one thing.
You kind of broke up there.
So if Republicans become in power, how fast could they undo this?
I would imagine that will happen very quickly. I mean, it's, I'm assuming you have, that would be incumbent in part on how quickly they sort of remake the Federal Trade Commission. And I'll confess, I'm not exactly sure what the appointment process is and whether, Lena Khan is going to have a term that allows for, I don't even know, but I would imagine that it's going to be about as quick as the Republican administration, if that were the case, could get a majority of the commission.
So even as fast as that could be done, which is slow, it's still going to create a period of chaos for at least, let's say, a year, 2 years.
No doubt. Wow. I mean, maybe I'll be surprised, and this will all be kind of a seamless transition to the dawn of a new day.
Yeah, it doesn't sound like you believe that, though.
Yeah. That's the hope that's left right there. You just got all of his hope right there.
Nice.
Yeah. So,
Greg, this has been fantastic. I first of all, just timely, and thank you so much for carving out time in your day. And I mean, it's just fascinating. And again, we're going to get to see it all unfold right in front of us.
That's right. Happy to come back on with you guys as we watch this kind of unfold in the coming weeks and months.
I was going to say, should we just book them now for June, October, and 100%. January? We'll even do November
after
at the elections.
Perfect.
He'll be our CNN guy. He'll give us the point breakdown.
This is going to be a bit that gets woven into the politics of November.
That's exactly right. Yeah. You'll be hearing about this all summer long into the fall.
Right. These are going into political ads right now. Yeah. There's people drafting political ads for or against. Okay, all that stuff's going to play out.
Yeah.
So we're going to hear about it. But again, once the elections happen, then the real chaos begins.
Right, that's correct.
So, Greg, are you committing now to be our play-by-play in November? We'll give you the big board and put some graphics up there for you too.
Happy to do it. Happy to do it. I'm happy to jump on with you guys.
It rides in Pennsylvania, which you can never know what's going to happen there. So
with that MSNBC, then
all I got to think about is CNN. The guy with white hair. Oh, he's on the big board and he's just pointing and stuff.
Thaffer.
No. That's oh God. I know who you're talking about.
Can't think of his name.
He's Shepherd. Is it Shepherd or no?
He knows down to the county and inside the county, down into the town. It's like, dude, you need to get a hobby.
He doesn't need. He doesn't need the earpiece.
Yeah.
It's real. Wolf. Wolf is it? Wolf Blitzer. Yeah. And then he's got the guy that does all the analysis and data. The younger guy. Yeah. That's going to be us in November.
That's we're going to need someone to actually walk us through this. Brother, thank you so much.
No problem. I enjoyed being on with you guys. Nice chatting with you.
Listen. That's the sound of the fully electric Audi Q6 e-tron. The sound of captivating electric performance, dynamic drive, and the quiet confidence of ultra-smooth handling. The elevated interior reminds you this is more than an EV. This is electric performance redefined. the fully electric Audi Q6 e-tron.